Welcome back to the LawNewz Network, everybody. This is Jesse Weber. Thanks for joining us in a day filled with so many special segments, talking about all different kinds of stories. We brought on earlier Adam Ghana to talk about everything that was going on in the Robert Mueller investigation, to talk about Jeffrey Willis, Luis Toledo, and now I want to talk to you about a brand new case that's come out that is very, very important. It's about Facebook. Facebook is being hit with a proposed class action federal lawsuit alleging that the social networking company purposely misclassifies employees to exempt them from overtime pay. This suit was brought on Friday, and it's brought by a former salaried client solutions manager from Facebook's office in Chicago. The woman, her name is Susie Bigger. She alleges that she and countless other Facebook workers are illegally classifying as managers. They're illegally classified as managers as part of Facebook's scheme to deprive them of overtime compensation. This is an issue we constantly hear in the news about companies doing this. And it's something we're hearing more and more happening in the tech industry. Well, I'm not the expert to talk about this, but I can tell you who the expert is. LawNewz's own Misty Marris. Misty, thanks so much for coming on to talk about this case. And while we have you here, we're going to talk about some other cases. But thanks for coming on.
Yes, thanks so much, Jesse, for having me. This really is a big hot button issue. And just so you know, this is a lawsuit filed in federal court. But a lot of companies face this issue directly from the Department of Labor. This is a big hot button issue. So the Department of Labor regulates how employees are paid, whether or not they're paid properly, can actually go in and independently audit a company to ensure that all of their employees are classified the correct way. So this is not just limited to these lawsuits that are popping up all over the tech industry. It's also a government agency that dives into these companies and really takes this to the next level to make sure that people are doing the right thing.
So in other words, companies, whether Facebook or not, they have to abide by state law and federal law when it comes to these worker pay.
Right. So first, the overarching federal law is called the Fair Labor Standards Act. The Fair Labor Standards Act is what you would imagine as the layman. You'd say, okay, that's who regulates what minimum wage is, how much overtime is, how many hours do you have to work per week before you get paid overtime. All of those laws fall underneath the FLSA, the Fair Labor Standards Act. Now, every state has a state equivalent to the Fair Labor Standards Act that also talks about what regulations and rules the state has in place. The federal law sets the minimum bar, so that's the minimum protection for the employees.
So you're saying
and
a
the
state
states can amplify it.
So you're saying if the minimum wage is $15, a state could give as much as they want.
Right.
That's really, that's what it is.
In New York, the minimum wage is higher than it is on the federal level. In other states, it's the same thing. It makes sense because obviously different states have different standards of living and that issue. So not only can they dictate the minimum wage, though, Jesse, they also can say what regulations, what qualifies somebody as an exempt or non-exempt employee.
And let's talk about that, okay? We have this lawsuit that's brought against Facebook by a woman who works for them. Let's talk about what her job is, what she thinks she's being classified as, and ultimately, what is her cause of action here? What is she saying exactly for a layman person to understand?
Yes, let's just break it down because these cases brought under the Fair Labor Standards Act can get very, very complicated and very, very technical. But at the end of the day, it's simple if you just break it down to its very core.
Sure.
So, under the Fair Labor Standards Act, it's presumed that you are not an exempt employee. What does that mean, Jesse? A non-exempt employee is someone that gets paid hourly. They have to make minimum wage. For every hour they work above 40 hours per week, that person needs to be paid 1.5 times their hourly wage in overtime. So that means you're getting a lot extra for working over that 40-hour maximum per week, and then you're making overtime pay. So in order to be qualified as an exempt employee, and that's somebody who has a salary, right? So some people get paid hourly, some people get paid, like hypothetically, say $45,000 per year to do a particular job. Well, in order to pay someone that way from a company perspective, you have to have that person be exempt from overtime pay. Now, what are the exemptions? There's several different exemptions. In this one, there's two different ones. There's executive exemption an administrative exemption that could potentially apply in this case.
So just to make sure we clarify, so those people who are on executive or a management position, if I'm correctly what you said, these are people that are paid by salary.
Right.
They're salaried employees. They have a salary scale, but they're not paid by hour. They're not paid overtime.
Exactly, and they're exempt from that overtime pay. So this case is all about, should we be getting overtime pay? That's what the plaintiff here is saying.
Oh, okay.
So to take it back a step, when you have, and in the law, Jesse, you know this better than anybody, and our viewers know it too, every single word has a specific meaning that's different than the layman's meaning.
No.
The legal definition of a word
course.
is much different than what you imagine in your own life. What do you think a manager is? Well, that could be a lot of different things.
Right.
But a manager under the law is a very specific legal term of art. And in order to qualify as under the management exemption or the administrative exemption, you have to fulfill a series of tests under the law to see if you qualify for that exemption.
Okay, the reason you're talking about this is because the woman who's suing, she was a client solutions manager. But what she's saying is she's not really a manager?
Right.
That's what she's saying.
So another interesting twist and turn in the crazy FLSA law that we need to tell our audience about in order to really break this down. One of the protections under the FLSA, and something that the Department of Labor will look into or a federal court will look into when you have a complaint like this filed, is, okay, why is the company considering this person a management level employee? Just calling them a manager isn't enough underneath the law. Think about how you could capitalize as a company.
Yeah.
If you were just going to say, oh, well, they're called a manager, so they are a manager for the purposes of the law. No, there's a very specific test. What the plaintiff in this case is saying is that she and other people that were similarly situated, so in similar roles, although they were called managers, and although that word manager was used, and although they were considered exempt employees because they're called managers, their duties were actually that of other employees who were paid hourly and also were paid overtime. So under the FLSA, there's a test. It's called the duties test.
Before you get to the duties test, and we'll get into that, let me see if I just understand this. This woman's working for Facebook. She's a client solutions manager. She's claiming she's not really a manager. She's getting a paycheck, though, right?
She's getting a paycheck,
so she gets paid every week or every 2 weeks she gets paid. She is paid hourly, correct? She was getting paid hourly, and now, but she wasn't paid her overtime.
She's not paid overtime.
But here's my question. How is Facebook going to say that is Facebook's argument, and we'll talk about what their defense could be later on, but is Facebook's argument saying that whatever you're getting paid a year through hourly pay, that's your salary? Are they claiming that you have a salary and you're not paid hourly? Is that what they're trying to say?
What they're going to say is that she falls under one of these exemptions. Now, you made a great point, Jesse. Yes, she's being paid hourly, but at the end of the day, what they're going to do is they're going to look at what that means over the course of any calendar year. And they're going to say that it satisfies the amount of money that a person that's exempt under the statute should make. So there's a certain lower limit as to what you have to make per week in order to be considered an exempt managerial employee.
Okay.
And also, they're going to say that her duties were commensurate with what a management level employee would be.
Let's talk about that, because she said in the lawsuit, CSMs, which are client solution managers, do not perform duties related to the management or general business operations of Facebook. Rather, CSM's duties constitute the principal production activity of Facebook as a social media and marketing platform. Their primary duties do not involve the exercise of discretion or independent judgment with respect to matters of significance. Is she just saying we're not managers? What is she trying to say here?
What she's doing is using every legal buzzword in the statute.
Okay.
So here's what the test is. You have to be able to exercise independent judgment. You have to manage at least 2 or more employees. So when you're talking about exercising independent judgment, that means that there's not somebody above you who's saying, Jesse, today you're responsible for doing X, Y, Z, or these are your tasks.
Okay.
You are exercising independent judgment in a managerial capacity. You're also overseeing other employees. That's what makes you a manager under the law. Merely saying that someone is a manager isn't necessarily indicative of qualifying for that exemption. So her argument is that her duties are the same as other people's duties who are non-managerial employees, and therefore they're entitled to overtime pay.
Okay.
So once you're entitled to overtime pay, when you think about this is what's interesting about a case like this, because you say, all right, well, she's getting a paycheck.
Yeah.
She's making money. So if you go back and you do the math, so these cases are very, very math heavy. If you go back and do the math, and she was making at least minimum wage per hour, so what's her damage, right?
Yeah.
At the end of the day. Well, the FLSA doesn't care. If you're misclassified, the company will still owe damages for what's called 1.5 times your hourly rate.
Okay.
Now, that's not minimum wage.
Okay.
Your hourly rate is what you made hourly based on whatever you made that calendar year, that hourly rate. And then for every hour that year that you worked anything over 40 hours, it's 1.5 times that.
Ooh,
now,
she's looking at
you're looking at a lot of money, especially when you're talking about class action. Each individual person is going to be an individual inquiry as to when they worked, how often they worked overtime. Now, the law also does what's called liquidated damages. And it's a very, very strict. The Fair Labor Standards Act is very strict on the businesses. So if you're owed, if they owe overtime pay, it can be 2 or 3 times more in a judgment in the court of law.
Right.
Even if, say, Jesse, we owe you $200. That seems pretty nominal, right?
Yeah.
Well, under the law, it can now be $600. That's just under the federal law.
Okay.
You can also have those liquidated damages under the state law, too. So
Okay.
there's a lot of different moving parts here.
You've handled these cases before, from what
Many
you've seen.
times,
Do you
yes.
think this carries weight?
Well, it's hard to tell because right now, all you have is a complaint. And
Yeah.
let's remember, a complaint is just the allegations. These are just the allegations. So this is only the plaintiff's side of the story. We saw Facebook come out swinging and say, no, there was absolutely nothing done inappropriately here. We classified our employees correctly. So before you see what Facebook has in their pocket and what they have in their hand as far as the stature of these employees, it's hard to tell. They said the right stuff in a complaint. This will survive a motion to dismiss, which would be that there isn't enough to even satisfy the cause of action. But it's going to take a lot of discovery to get there.
Facebook made a statement. They said this lawsuit is without merit. We will defend ourselves vigorously. Companies that are in this position, what are their arguments against it? You said that they did classify appropriately. Explain, let's give an example. We have this woman, she's client solutions manager. How are they going to say we classified you appropriately and you were not deserving of overtime pay?
Right. What you'll do is you go back and you look at job descriptions. You look at every aspect of your job.
What about the contract?
If there is a contract. I mean, many times, I don't know if there's a contract in this particular case. Many times people don't necessarily have employment contracts.
Okay.
They might have an offer letter. You look at the handbook. You look at the structure and the hierarchy of the company, an org chart. So that's an organizational chart that would show who's in charge of who and what. And then from there, Facebook would raise those arguments on both levels because this is what it all breaks down to at the end of the day. It is, number one, were your duties commensurate with that of a management level employee? And then there's a specific test. Were you able to exercise independent judgment? Just as we said, what the plaintiff alleged that she was not able to do, Facebook will come back and say, well, this person in this role could in this way, that way, and this other way. The other piece will be that they were actually properly paid, that they were paid enough to fall under that exemption. So that's what Facebook will focus on. Those two tests, and you have to satisfy both, the pay test and the duties test. And that's what Facebook's really going to look at. But I will say, 99.99999% of these cases have extraordinary consequences for the company and often result in settlement. And that's because this is not just one plaintiff bringing a case. This is a class action. And very often, federal courts grant class action status. So what's a class action, you might ask? So it is an action brought by many, many, many different individuals who are similarly situated. If you have a one individual plaintiff, that's one thing.
So you're saying everybody who's a client solutions manager or something that has the label manager but's not really a manager in Facebook?
It could even go beyond that.
Okay, so
because all it requires is similarly situated and damaged in the same way. So there might be other categories of employees that could be implicated in the suit. You're not limited to, when you bring a class action suit, it's not limited to just the position of the plaintiff whose name is going to be on the complaint. So this person is going to be the class representative, the person that brought this case. And then everybody else will be any employee that could have potentially been misclassified. It could even fall beyond the managerial exemption. It could go into the administrative exemption. In a class action lawsuit, they go after everyone. And the law, Jesse, is so employee friendly and broad that they will be brought into the case. So now you're talking about a large scale litigation. Ooh. But in this particular case, when it comes down to misclassification cases, they're a little bit more difficult to resolve because part of that resolution might require the company to actually go back, statute of limitations 6 years, look at employees who have held the same or similar positions for 6 years, change their classification from exempt to non-exempt, and potentially owe overtime for that entire pool of employees. Not only that, there's also tax consequences. So now you have to pay those employer side taxes to the IRS. So there's so much more to it than just a single plaintiff lawsuit.
But here's what I'm confused about, okay? If my position changed in a company, if I did become a manager, if there was a change, I'm no longer an hourly employee, wouldn't there have been some sort of announcement of this? Wouldn't there have been some sort of contract? Wouldn't there have been some sort of indication that my role changed?
Yes, and that's exactly, you bring up a great point. That's why anytime somebody changes a position in a company, you have to look at the inquiry again. You have to look, is this person exempt or non-exempt? Did something change in their employment status? And that all comes back to what we talked about. It's actually practical stuff.
Yeah.
There's no magic formula. It's what did you do on a day-to-day basis? Who did you report to? Were you overseeing other people? Did your job require you to exercise independent judgment, or did somebody tell you what to do? So what the plaintiff here is arguing is that she's just basically doing the operations, for lack of a better word. She's just making everything work. She's not doing anything independent, exercising her own judgment, or really dictating the direction of any of her tasks.
Misty, why do we keep seeing this happen? I know Facebook has had in the past complaints about paying workers. Groupon was a subject of 2 overtime lawsuits by sales reps in 2011. That company paid $2.5 million last year to 2,024 employees, and that was about $778 for each person for an average of 2.2 hours of unpaid overtime per week. Why do we see this happening with Groupon? And I know Facebook has had trouble in the past. Why does this keep happening?
The law is constantly evolving, Jesse. And it's actually getting more expansive to include more types of employees into these non-exempt roles. Misclassification cases are really, really big right now because a lot of companies, and look, I represent the companies in these types of cases all the time. Very often, the allegations will be this was intentional, it's to save money, it's to gyp your employees out of overtime. Very often that's not the case. Many times they have received advice from consulting firms, maybe even attorneys who have told them that you can properly classify employees one way or another. But the law is really expanding on this front. And the Department of Labor really dictates where the federal law is going to go. So the more employees that are getting looped in to being owed overtime or being in this non-exempt status, the more companies need to evolve with the law. And that's really where it's coming from, Jesse, especially when you're talking about Groupon, Facebook, tech companies. These are companies that have grown exponentially over the years, that are adding more and more new roles to their company every day. And with each role that's added, that entire checklist of inquiry needs to go on in order for companies to avoid this type of liability, because those numbers that you're talking about, that's common. You're talking about millions and millions of dollars in settlements.
If they don't want to settle, because that could give an instance that we settled in this way, we gave in a bit. If Facebook wants to fight this all the way to court, and this is certified as a class action, and is there any chance, or how would they be able to win? Is there a way that they could win, and that would change the landscape for these kind of suits moving forward?
Sure. I mean, it's such a fact-sensitive inquiry. This is what's going to happen. I mean, look, if they want to litigate this case on through the system, what happens is it's certified as a class action. All of these people are sent a notice. They have the ability to opt into the class action.
Well, it's not a class action yet, right? It hasn't been served.
You're right.
Isn't there a chance that it couldn't be classified as a class action?
Probably 1% chance that it would not be a
class
action.
Why wouldn't it be?
It's class actions. The law is very, very broad. You have to show that the other people are not similarly situated and don't have similar damages. So the minute you have people who are categorized, and it's based on the allegations also, Jesse. So you're not using any other facts. Are the allegations sufficient to say that there's a class action.
And you feel based upon the complaint, what you see, it's
Yes.
a strong chance. So, okay, so it's a class action. If they fight it, if Facebook fights it and goes to court, you're saying there's a chance that they could win, and it might change the landscape about these
They depose
suits.
every single person.
Yeah.
They bring in every single document relating to that person's employment. They go through all of the facts relating to each individual person's employment with the company. They do extensive documentary discovery. You may even see going back into why these people, looking at the intent of how they classified certain employees.
Yeah.
You may even get some records from consulting firms that would normally be privileged or would never be discoverable. But sometimes that comes into play, especially in a case like this, where the allegation is that it was intentional.
If they settle, if Facebook ends up settling, what does that say to the industry?
Well, here's what I do think about settlements, and what I think is a real misnomer.
Because it's important for anybody who works at a big company or is management in a company. I think it's important discussion for anybody who hears this.
Yes. Oh, absolutely. I mean, look, this impacts everybody because we're talking about Facebook. We're talking about a huge multi-billion-dollar operation. But these laws apply to small companies, mid-sized companies. It really impacts everybody. With respect to settlements, Jesse, I think that there's a real problem in how settlements are portrayed in the media.
Okay.
And that's because very often people, and I understand why, think settlements are indicative of guilt. You did something wrong. But that's not really the case. Sometimes they're very, very strategic business decisions as to why you might settle a case. And one of the reasons in a case like this could be, well, we will correct, perhaps, we will change the classification of certain employees moving forward. We will make right what people believe they're owed, but it will cost less for us to do that than it will to litigate it for the next. And look, these aren't quick.
Yeah.
This is like 5-6 years.
Yeah.
So, and maybe it's too distracting to the business, to the evolution of the business. So there's a lot of business decisions that go in. If the case settles, look, it's again, that is a strategic business decision. It's not necessarily saying that this is right or wrong. Now, interestingly enough, we know most settlements are confidential, right? That's one of the big pieces of settling a case is keeping that settlement confidential for the company because most of the time the settlement agreements will say nobody is admitting fault or guilt.
Yeah.
Interestingly enough, under the Fair Labor Standards Act, all of these settlements would have to be public. They have to be approved by the court and publicly filed. So there is a huge push to protect employees and for the public to be aware of what companies are doing and where these cases go. So it is a very, very employee-friendly law. It's great because employees have the ability to know exactly what they're entitled to. You'll see if you walk into any workplace, you're required to have posters on the wall that say your rights under the Fair Labor Standards Act. There's laws in place, commonly known as whistleblower statutes, that if you believe that there's something wrong with the pay practices or the working conditions where you work, you can complain without retribution. So there is a lot of protections in the law built in to protect employees against unfair pay practices.
I got to tell you, I think it's very interesting. And again, Facebook, they have the money to fight it and they have the money to settle for it.
Yeah, it's like where do they want to spend their money? Do they want to pay it to Misty to defend their case? Do they want to pay it to somebody else?
I want them to invest in putting in a photo feature that I can upload more photos of myself. That's what I ultimately want.
There we go. We'll see where it all goes.
See where it goes.
Let's, Jesse, let's make sure that we keep following the story because I think we will see it evolve over time.
Yeah,
and you'll see more positions implicated in the case.
And I think it's very important, and luckily we have you on who's an expert in this area to talk about it. But so yeah, we'll follow Facebook, and thank you for talking about that. While I have you here, I do want to focus on some of the other cases, the meat of our cases that we're talking about here on the LawNewz Network. Let's talk about a little bit of Luis Toledo, which is what we just played before you came on. That verdict, okay, that verdict came out guilty on all counts. Is it what you expected? I have to say it's what I expected.
Yeah, it is what I expected. I mean, I also, hosting the show, watching the case unfold, watching the testimony, this was one of those cases where I really felt that the defense, they did not have much to stand on. Their best argument was that there wasn't a body, that you couldn't really prove when the murders took place, that you couldn't really prove how it was facilitated. But as we know, no body murder cases, you can get a conviction. Here's a great example. What I really thought the defense could have done is put more focus on getting him off with respect to the kids, because there was a lot less evidence relating to the murder of the 2 children
Well, what about the
than there was the
blood?
mother.
What about the blood on his boot that belonged to Talia Otto? What about the blood in the trunk, the trunk mat or the floor mat that belonged to Talia Otto? What about the blood in the closet and the master bedroom and the bathroom? Excuse me. That there was all this blood. And who else would have done it besides Tyshawn Jackson with an axe?
Exactly. And I'm not saying I disagree with the jury's verdict.
Yeah.
I'm talking about the strategy.
How would you have done it? How would you have done it a little bit differently?
I almost think that you would need to concede, and I understand why the defense didn't do this, but I'm looking at it from, and maybe, hindsight's 20/20 here, but we know that the death penalty is on the table because the murder of the 2 children was an aggravating factor. So in a case like this, what you want to do is keep the death penalty out, right? That's really the goal. I mean, the facts here are so bad. You have a confession.
Yeah.
I mean, I don't know how the defense attorney came out of the gate in the opening statement and talked about how there's no body, there's no, how can you ever prove a case without the body when you have the person who's accused of the crime actually confessing to the murder of his wife. I think that in the law, one thing, you cannot set the jury's expectations improperly right from the get-go. If you're going to present to them a case where there's no evidence of a murder, you better have no evidence of a murder, and you better not have a police interrogation video where somebody is confessing to the crime.
I mean, what the defense tried to do, or what I saw that they tried to do, was say, look, our client killed Yesenia Suarez, but he did it in a self-defense. She was attacking him. He did his self-defense. He karate chopped her. He didn't have the intent to kill her. It was just a terrible accident. And as far as these 2 kids, well, Tyshawn Jackson was there. And Tyshawn Jackson is a man who has had trouble with the law, and he didn't want to get in trouble, so he took matters into his own hands, and he brutally killed these kids. What didn't match up to me was that story didn't quite make sense, and I think it was another situation where if you have 3 bodies that are missing, and they're all killed around the same time, that if you're able to see that he killed one of those people, then he necessarily killed all 3 of them.
Which is why the jury verdict, not shocking, right? Especially when you have 2 little kids.
Yeah.
And you're talking about the evidence certainly pointing to Toledo. My suggestion is that I really think what the story you just told, yes, that's what the defense was trying to go for. But I don't think that's the way they opened their case.
Yeah.
They did not start off with, look, this was a terrible tragedy, self-defense, emotions were high, maybe even a heat of passion type argument.
Yeah.
They opened with no body,
Yeah.
no body. And that was a mistake, in my view, because once you set that expectation for the jury, and then we saw all the evidence unfold, it was going to be impossible to backtrack and take the kids out of the equation from a verdict standpoint.
Yeah.
So I think that there could have been a lot more focus on, look, it's not a pleasant thing to do, but really setting forth that self-defense argument, conceding to that one murder, gain your credibility by saying, yes, this is what happened with respect to the wife, but the kids, again, there's another person, raise reasonable doubt. I'm not saying it would be successful. There was an overwhelming amount of evidence here in this particular case. There was obviously a lot of issues with the rage that we saw in the day before the murder. I mean, there was a lot here for the prosecutors.
Wouldn't have been another strategy, if you like to take what you just said, is to say, okay, the defense can say there's no bodies. How do we know they're dead? Now here's the thing. They were gone for like 4 years. No one from their family, friends has ever heard from them. There was no financial activity in Yesenia's bank accounts. The kids they never came back to school. Having said all that, if the defense really put more of their efforts into trying to show there was some evidence of them being alive, maybe there was a sighting here or there, and if they tried to show, look, I'm taking also if Mr. Toledo didn't confess, but if you can have a case where there's no body and you can show that they're possibly alive and they were in a destructive relationship and she just left and took the kids and wanted to disappear for a few years, would that have ever been successful?
In this case, probably not, because you made a great point that there is this confession during the police interrogation. There was enough evidence to show that a death occurred.
Yeah.
However, Jesse, yes, that is a very common and a great defense in a no-body murder case where you can show, look, this person might have just skipped town. They were looking for another life. One of the things that you often point out as a defense attorney, exactly what you said, this was a destructive relationship. This woman wanted herself and her children out of the relationship. She has ties to some foreign country. She has family overseas. She could have easily just gotten out, never to be heard from again, and there's no way that you can show that any sort of murder occurred. The problem we had in this case, we had the blood, we had some forensics, we had the incident the day before, and we also had, to me, one of the most damaging parts of the case is this 6 a.m. rendezvous in the parking lot cleaning out the car. So you really didn't have those facts here. But in a no-body murder case, that is the best defense. Look, there's no evidence that this person is actually dead. So how can you convict someone of murder?
I would have imagined that maybe in a situation where the defendant has multiple resources and can track people, maybe as part of an organization, where here you just have a guy who, you know, it was just him. But if you have a defendant who was maybe wealthy, had the resources to track people, and if his wife and 2 children left him and had the ability to track her and see where she went, then you might have understood a situation where she did go into hiding, and there's really no evidence that she disappeared. But as you said, there's just too much evidence pointed against him. This guy, when the verdict came forward, said, "I wanted to be sentenced to death." He said that. We had Adam Ghana on earlier to talk about that. He said it might be a factor that goes into the weighing of the jury, but just because he wants death doesn't mean he's going to get it. What did you make of that statement and for the future of him?
Well, look, I think that it was very tied to what happened in that police department, where we know that after he was interrogated, he did attempt suicide right there at the police department. Again, he's making that comment that he wants the death penalty. Certainly, look, I don't think his lawyers are going to let him get up during the phase of the trial where you're actually going to be sentenced to death and say something like that. There could be a competency issue with respect to the defense attorneys. I mean, that's what I would argue if my client wanted to do that, because in some cases your client can make statements and testify. It's really their choice. Certainly, it's a factor that the jury can weigh. Say the jury does hear that and the jury does weigh that factor. Look, you might get some jurors who say, "I don't want to give you what you want.
Yeah.
I just convicted you of murder.
Yeah.
If you want death, I'm going to give you life in prison." I mean, it really.
I thought about that.
It doesn't necessarily mean anything, but it certainly does show what his mindset is. And look, he was found guilty by a jury of his peers, so he's guilty under the eyes of the law. We'll never really know. We will never really know what happened, but it certainly shows that. Maybe there's an element of remorse. Perhaps the defense attorneys will flip it that way.
Well, that again, the idea of throwing in some mitigating factors here might be kind of tough, given the nature and the brutality of this crime and the fact that these bodies were never found. I'd love to hear your thoughts on mitigating factors, but also the idea that you need a unanimous jury verdict to find him eligible for the death penalty, find him, sentence him to death. And that's not an easy thing for human beings to do. What are your thoughts on the mitigating, aggravating, and as well as a jury being able to do that? Right.
So there's a lot going on in this particular case, because as you said, there really are some very horrific facts. And whenever you're dealing with children, and it's such a sympathetic, the fact that the lives of 2 children was taken is something that a jury is certainly not going to ignore. As a defense attorney, even when times are tough, it's your job. You present those mitigating factors, even if your only mitigating factor is remorsefulness.
Yeah, sure.
And I mean, maybe that's all you have.
So you would show that video and say, "Look at this guy. He was so in the video in the interrogation room. He was broken up about it."
It's possible, and that's a possible tactic. There are other tactics that you could use just to show remorse. You could have a prepared statement. You could do many different things, but you have to try if you're going to.
But I have to ask you before I forget. This is a guy who fought this out. He fought this verdict out. He said he was not guilty. He pointed the finger at another individual. So you can't have it both ways. You can't show remorse, fight it, and say you're not guilty, and then as soon as you're found guilty, say, "I want to be sentenced to death."
Yeah, but I do think that there's something there that you could work with from a defense perspective, and that's that, yes, we know that he, early on, and in that interrogation video, he said, "Look, it was a self-defense killing of my wife, but I'm not responsible for the death of the children." Again, yes, you do have a jury verdict that says, under the eyes of the law, you're responsible for the death of the children, but those facts are still going to come in when you're talking about the penalty phase of the trial. A defense attorney is going to argue, think about, there's mitigating factors here. It was a self-defense killing, XYZ. And you're going to still talk about some of those underlying facts. Remember, even though there are findings of fact with respect to the liability phase, to the guilty phase of the trial, you can still litigate some of those facts in the penalty phase when you're talking about mitigating factors. So you're going to see that come up again. This is a case where, look, I could see a jury going for the death penalty because of the fact that you have 2 children involved. You asked, is that too difficult for a jury to do, to say that we're going to take someone's life? Well, presumably, when this jury was selected, that was a big part of the questioning in voir dire.
Sure.
Because whenever you have a death penalty case, that is something that's going to be a prominent question, and jurors who said, I could never sentence somebody to the death penalty, or I'm completely anti-death penalty, are probably going to be taken out of the running.
Yeah.
Because when you have a death penalty case, you got to go in with that, the clean slate, that your political opinions about what the death penalty means or how you would personally feel about giving a death penalty result is taken out of the equation, and you're basing it on the findings of the law.
So they're ready. They're ready to deliberate on this issue, and it's really horrific. We covered it, and we will cover also the death penalty phase of this. And Misty, we're going to have to hear what happens. While I have you here, I want to talk about our last case of the day. This is the case that hopefully we will be streaming here. It's the Adam Matos case out of Florida, Pasco County, Florida. Adam Matos, he has been accused of brutally murdering his ex-girlfriend, Megan Brown, her 2 parents, Gregory and Margaret Brown, as well as her boyfriend, Nicholas Leonard. It's a crazy case where an ex-boyfriend kills her parents, and her ex-boyfriend. It's a nightmare just thinking about it. Brown, the victim here, the ex-girlfriend, as well as Matos, the defendant, they were the parents to a young boy, a 4-year-old boy at the time, and Mr. Matos will face the death penalty if he is convicted. Misty, I want to talk about this case. We saw jury selections happening. We're anticipating the case to start pretty soon. We don't know that much about it yet. We know that Megan Brown died of a gunshot wound to the head. Her father died of a gunshot wound to the torso. Her mother, her hands were found bound behind her back. Her head was covered with a bag. She suffered blunt force trauma to the head and was asphyxiated. And the boyfriend died of blunt force trauma to the head. This seems like a very personal attack on all of these individuals. It's still early in the case, but is that the way that you would flavor this, that this is a personal attack and it's somebody who knew these people and it wasn't just some random stranger?
Yeah, that's certainly what it looks like. I mean, this does not look like, oh, I just happened upon you and I wanted to rob you and it's the killing and the commission of a robbery or something like that. It really appears to be something very specific, something very calculated. The fact that you have this whole family involved in the death is certainly something that the prosecutors are going to be focusing on. I mean, look, from the outset of this case, from what we know, there appears to be a lot of evidence pointing to the defendant, but I hate to make those snap judgments because you really don't, and perhaps that's my defense attorney background, you really don't know until you really see the evidence come out in a court of law, which is why LawNewz is such a great forum to watch these trials, because you're actually seeing what happens in the courtroom as opposed to what's just written in an article or what salacious piece comes out in the media. You're actually getting to see the case unfold.
You're a good spokeswoman
you know what, I
for
really like
LawNewz.
LawNewz.
Yeah, I would think so. One of the things that we'll probably see in the case is the statements that Miss Brown made before this event took place. She communicated with her boss, she communicated with the sheriff's office, and she communicated with her friend that she felt her life was in danger from Mr. Matos, that she felt that he was going to kill her. I can imagine those statements coming in.
I would anticipate they would come in. They're certainly relevant to what could potentially have been the precursors to this death. One thing that I like to talk about in cases like this is what happens here. I mean, these are kind of the classic domestic violence cases where there's reports, absolutely unfortunately, where there's report upon report of violence between the couple, their fear of lives being at stake, and eventually evolving into a death. It's really a sad state of events, and from a policy perspective, what can be done to stop these types of cases? I mean, in New York, we have mandatory statutes where somebody who is immediately arrested if they're involved in some sort of violent altercation in order to give them that time to cool down. It's just something that is certainly a common theme in some of these cases. I mean, we just talked about it in the Toledo case where you have something in a relationship. Also out of Florida, evolving into the death of one of the partners. And it's certainly, it's just a terrible tragedy. and hopefully something from a policy perspective that we can all think about. What can we do to make this better?
What it seems to be here more than Toledo is there were people knew that something might have happened, and it seems that if they knew that this could have happened only a few days later, there should have been more that was done to prevent this. And that's really going to be something that I think is brought up.
Certainly, those can be inquiries into the investigation of any prior complaint that was made. Why or why not was an arrest not made? What exactly happened? Oftentimes, domestic disputes are very tough because many times somebody will recant. Many times there's a reconciliation. There might be something that happens that then is sort of swept under the rug because the relationships are ongoing. They're very difficult cases. So that could certainly be an inquiry, perhaps even from a civil point of view. You may see a case if somebody looked into, if an agency looked into a domestic dispute and failed to take proper action. You could see negligence cases down the road. Of course, now we're dealing with the criminal trial, but it's certainly something to watch out for.
I agree with you. Let's just talk briefly about my last question to you about this case. Let's talk about some of the behavior that we know of Mr. Matos beforehand. This took place, or while this crime was taking place. We know that the day before the bodies were found, a neighbor reported seeing a man that matched Matos' description spraying water in the garage and sweeping it out of a side door. Deputies had spoke with a neighbor who said they saw Matos sometime between midnight and 1 a.m. on August 29th. He stated that Matos appeared to be out of breath and sweating. We also know that Matos had sold the the 6 dogs that belonged to the parents here for $50 a piece through ads on Craigslist. And they also said that Matos bought a long-handed shovel using one of the victim's debit cards. This is just me reading what we know so far.
Right.
If this is introduced properly into the court, what do you see here?
Right. I mean, look, from what we know so far, from what's been reported in the media. Again, I don't know if some of those witnesses if there will be evidentiary reasons why they can't testify, or perhaps those identifications aren't so rock solid the judge will keep them out. But from what you just read, if all of that evidence comes in, I think the selling of the dogs, the use of the debit card for
you don't
the
see that every day.
You can easily, as a defense attorney, unless you have a lock-solid identification with respect to the guy that matches his description, cleaning up, you might be able to cast some doubt on that. Well, do you really know, was it this guy? Are you sure? Couldn't it have been somebody else? How tall were they? You may be able to cast doubt on that when you don't have that direct identification. When you do have some of that other evidence, you have the selling of the dogs, you have the debit card use, there is certainly a lot of problematic aspects from the defense perspective. And the question is, what does the defense have to counterbalance that perhaps we haven't heard about?
Well, that's going to be the interesting part of this trial, and as Misty said so eloquently, you can watch it here on LawNewz Network to see more about it. Misty Marris, thank you so much for coming on to talk about Facebook, Toledo, and as well as the case that we will be hopefully covering, Adam Matos. Thank you so much.
Yeah, thanks, Jesse.
Of course. So as we said, we are